Welcome, you're on the Fringe Show. I'm your host, Tatjana Zalan, and I go live every Friday at 2 p.m. Dubai time. The Fringe helps you to navigate the rapidly changing world and increase the odds of your success. Here, we discuss technology, startups, entrepreneurs, and mental models of successful people so that you too can take advantage of the opportunities in the new digital world. Today, on episode 33, I'm going to talk about a very interesting topic, at least to me. Do you own your own NFT? The NFT market, as you probably know, has got absolutely vertical, yet the legal regime that governs NFTs has fallen behind. The laws for NFTs are intended for a much older digital economy, and it's focused more on licensing than the sales of actual digital goods. Full, real digital ownership, believe it or not, is still elusive, and the law has not kept up pace with demand for unique digital property. Who is the show for? This show is above all for buyers and sellers of NFTs, investors, collectors, devotees, creators, and as well as NFT startup founders. If you're building wealth using digital assets and collecting NFTs, the show for you is a must because you need to understand the risks of current regulations. It's a live show, let me remind you this, so please let Facebook identify you. And also, just a usual disclaimer as usual, it's not financial or investment advice, nor is it legal advice. All I'm doing on the Fringe Show is providing you with informational and educational material. I decided to kind of study this topic in a little bit of more depth because of personal interest. Firstly, one day I may want to own an NFT, a real piece of art, and I want to know and understand what is it that I actually own. And secondly, I'm involved in a digital art gallery, and I think it's important for all founders to understand the terms and conditions on what they use to so-called selling the digital items. Because I'm obviously not a legal scholar, I'm a business academic, I'm drawing on a lot of work that has been done recently by legal scholars and international consultancies. And I put a couple of links below the work that I'm quoting and I'm also drawing on. I want to begin with a little story here just to illustrate the intricacies and complexities of the whole issue of ownership. In April 2021, a sketch by celebrated neo-expressionist artist Jean-Michel Basquiat drew considerable attention and press coverage due to potential copyright dispute. Basquiat is a very well-known artist. He passed away in 1988, so he's not a living artist, but his artwork is critically acclaimed and it often sells for considerable amounts of money. As an example, a painting by him, which was called Untitled, sold not that long ago in 2017 for well over $100 million, and making it one of the most expensive art sales in art history. Daystorm is an art collective that owned the Basquiat mixed media work that was called Freak Home with Pagoda. And they announced that they would be making it into a non-fungible token or NFT. This wouldn't have generated probably that much interest were it not for the statement that this NFT would transfer not only the ownership of the digital file, but the new owner would be given the choice to destroy the original work if they so desired. That really caused an uproar in the arts community and prompted several legal questions as to whether that would be possible under copyright law. There is something distasteful, as I'm sure you will agree, in the destruction of a physical work of a very important 20th century African-American artist. And that was done, I believe, and many other analysts believe, to generate interest and scarcity in a ploy to boost the price at the auction. The outreach reached the art licensing agency that manages Basquiat's work on behalf of his estate, and they declared that Daystorm only owned the physical copy of the work, but did not possess any of the accompanying copyrights. So that poses a very interesting question. What is ownership in a digital economy? What is ownership of digital assets? And the key issue with the ownership of digital assets is whether we are referring to, and NFTs for that matter, whether we're referring to true ownership that should be treated as personal property and therefore treated as a sales contract, or whether buyers are just users of services and therefore they're governed by license contracts. The intellectual property license is the dominant legal paradigm right now for relationship between people and assets online. The key feature of the license contract is that the rights holder continues to exercise power over the licensee, and at the end of the contract duration, the licensee has nothing. That's just the terms of a license contract. The key feature of a sales contract, by contrast, is conveying a property interest. It's that once the sale is concluded, the seller has no power whatsoever over the buyer. Once the buyer pays and the seller sells and hands over the property, then the deal is done and dusted. What does it mean to have ownership? What does it mean to own art? I will make this illustration with art because this is something that probably interests a lot of you, my audience, but also it interests me personally. Ownership, generally speaking, is a very old concept. It's as old as human civilization. In law, property is defined as the right to enjoy and dispose of things in the most absolute manner. This is clear when it comes, for instance, to buying your house. You bought it, it's your property and absolute. By contrast, IP, intellectual property, is a much younger concept. IP is a branch of law that deals with all the rules applicable to intellectual and immaterial creations, which are elevated to the rank of intangible property by the law. The law designates patentable inventions, trademarks, and creative content as intangible assets that might be appropriated and owned. But the law, and that's a very interesting point, and I bet not many people know about that. The law does not recognize mere data or mere information as being protectable by IP rules and therefore capable of being owned. In democratic societies, information and data, just like ideas, are free-flowing. Data in itself is not something that can be appropriated or owned. So now, if you apply this logic to the world of art and NFTs more generally, you end up with the following situation. Two kinds of property exist in physical artwork, the tangible property and the IP. However, only one kind of property exists in digital artworks, and that's the IP. What it means that unlike in physical work, a digital artwork cannot be owned by two persons or entities at the same time. Only one property exists, and that's the IP of the creator. I'm sure you understand, those of you who are listening to this podcast, what an NFT means and how it works. But just for consistency, let me give you a quick recap. NFT stands for ownership of something not directly stored on the blockchain, although it can. It's a piece of digital art, just take as an example. It's a token representing digital art, which may contain a URL pointing to the art, plus a hash of the art file as proof. An NFT might convey an ownership interest in a piece of digital art, an asset in an online game, a card in a collectible trading card game, or a plot of land in a virtual world. It can also convey rights to a real-world asset like an RFID-linked consumer goods. Think about Nike sneakers as an example, or a car that only unlocks and drives for the token owner. The value of NFTs rests on a simple value proposition, that the buyer of NFT owns it free and clear. The problem with this value proposition that it is not entirely true, and I will expand on it later why this is not the case. But now let's have a look at this service or license view of ownership of digital assets, and particularly NFTs. Many have tried to draw an analogy between purchasing a digital art NFT to buying the physical original of a painting. The analogy they would draw, for instance, is that buying an NFT of digital art is similar to purchasing the Mona Lisa. But this analogy does not hold water. When a person wants to buys a painting from a gallery, what they buy is the tangible property, that is the canvas and the paint, not IP. NFTs do not replace canvas and paint because NFTs are nothing more than information. And information, as I just mentioned, cannot be owned according to law. Reed Smith, in particular, that's an international legal consultancy. They've done lots of research in there, and they show that most NFTs that are minted today are far closer to providing a service, like the authentication of a work of art, or granting license, a limited permission to use and enjoy the digital art. But very rare are the cases where true ownership is being passed to the buyer. The key takeaway from this is if you're a buyer of the NFT, you should understand what you're buying, in inverted commas. For creators, it's equally important for those who are tokenizing artwork. And you need to be careful in how you go for the market, approach the market, and advertise your NFT. Advertising the sale of artwork could be potentially misleading if all the NFT creator is offering is a digital certificate. So please bear this in mind. So that's the licensing view, right? Another view that's now emerging about ownership of digital assets is the true ownership view. NFTs, according to this view, are personal property, not contracts, despite what we have in this space like smart contracts terminology. They're also not pure IP licenses, despite the currently governing law of digital assets like ebooks. Because transactions in NFTs are in the form of sale, the law of sales of personal property should apply, according to this view. The value proposition is that the buyer of NFT owns it, but it's not entirely true, as I've just mentioned earlier. And there are two central difficulties that we're currently facing here. One is the technological implementation of NFTs that enables those who sell NFTs to exert what some lawyers call lingering control, some kind of residual control of a fully bought and paid for asset. And the second difficulty is that the legal framework surrounding NFTs is not conducive to ownership. And I'll unpack these difficulties one by one. So we're starting with lingering control or residual control. NFTs are sold definitely on the following representations. An NFT token is the asset it represents. The purchaser owns the asset. The seller of the asset has got no control over an asset once it is conveyed or passed through, and the buyer of the asset can do as they wish with it. NFTs are sold on the promise that's similar to the promise one receives when buying a physical object, according to that. When a person buys a book from a brick-and-mortar bookstore that owns, he or she will own that physical book and will be able to do whatever she wants with it. Sell it, read it, you can throw it away, or you can donate it, you can burn it. Digital property has never carried such a promise. And as you know, those of you who've purchased like movies from Google Play or ebooks from Amazon, you don't own these digital assets. All you have, you have a license to use these assets. There are three technical restrictions associated with this residual or lingering control. One is the ability to code the transfer function of the token to be pausable. So that's as from pause, right? Such that the original creator of the token can pause its future transfer. Consider a collectible card game whose creators might want to take a game-breaking card or out of circulation for whatever reason. Then the second type of restriction are the kickbacks to the original content creator for downstream sales through a smart contract, or what is known in the space as secondary sales or even tertiary sales. And this is the case of many NFT markets such as Rarible. But the token is not itself the art. The token merely shows that the token and the art have an immutable relationship between each other. When the owner of a token tied to a piece of art on Rarible goes to sell the art, a portion of the sales price will be conveyed back to the creator of the token, which is completely different from what we have in the physical world. When we buy a car, we do not expect a portion of its sales price to be forwarded back to the person who sold it to us when we initially bought it. The problem is that is not that a marketplace takes a cut of the sales. Auctioners do that. eBay does that, or Sotheby's, or Christie's. The difficulty is that by coding the seller's cut into the token, the seller becomes a part owner of the asset. They take a cut wherever and whenever this asset is sold. And then there is a third difficulty as well, which is called wrapping. It's a technical term. Smart contracts can be hacked, as we know. So the code needs to be altered sometimes, or patched, as we call it, to deal with all these vulnerabilities. The process of doing so is termed the wrapping. An existing smart contract can be wrapped inside another smart contract. Users are then migrated from contract A, the original contract, to contract W, which is wrap contract. And a user who wishes to insist on the features of the other contract, of the original contract rather, finds himself out of date, and the value of this asset can be greatly diminished and possibly even destroyed. The second difficulty with true ownership of digital assets, according to the sales contracts view, is that the legal framework that we're currently using is not conducive to ownership. The IP regime that currently governs the internet is literally hostile to digital person property ownership, imposing the contract and licensing regime of IP instead. So the IP rights holder can claw back significant rights from buyers. Let me just give you an example. I'm sure everybody remembers the CryptoKitties craze of 2017. Well, in 2018, Dapper Labs, these are the creators of CryptoKitties, they created 3 special CryptoKitties based on NBA star Stephen Curry. The creators of the Curry kitties, as they called them, did not have the rights to Stephen Curry's likeness. And as a result, Dapper Labs had to put all these Curry kitties from their website. And just to wrap it up and give it a little bit more life to this rather dry talk, but very, very important for you as a creator or you as a buyer of or seller of digital property, of NFTs, let me give you 3 examples of very well-known projects and what they actually say. One is X Infinity. X Infinity became the first NFT series to break the $4 billion in sales. So it's a hugely successful project. And consider the license conditions imposed by X Infinity. Although X Infinity expressly buys the X's, which are the creatures there, on the grounds that they're owned and may be resold for profit, the license conditions imposed by XC tell an entirely different story. The license notes that all the graphics, including those of the sold X's, are still owned by the company, and the company operates under the law of the Cayman Islands. This is the precise quote from the contract. I think it's quite telling. Unless otherwise indicated, they say the site and the app and the smart contracts are our proprietary property, and all source code, database functionality, software, website design, audio, video, text, photographs, and graphics on the site and the apps, collectively known as the content, and trademarks, service marks, and logos contained therein, the marks, are owned, controlled by us, or licensed to us, and are protected by copyright and trademark laws and various other intellectual property rights and unfair competition laws of the Cayman Islands, foreign jurisdiction, and international conventions. So it's quite clear that the all-important copyright, the right to make reproductions, that is absolutely necessary to convey a digital item from one person to another, is expressly retained by EXI. Owners cannot exploit their access for commercial gain. The impression, however, which is left by the EXI terms of use is that EXI wishes purchasers to buy and pay premium prices as if they own access, but intends to claw back at the same time most of the promised ownership rights through the terms of use. Everything that's promised by EXI NFTs, purchaser ownership, and robust aftermarkets is taken back by this user and license agreement. Users either have to agree to these terms, or if they don't, they can be removed from the site, service, or even interaction with the ownership smart contract. Another example, CryptoKitties. CryptoKitties' nifty license permits owners of CryptoKitty to use their kitty to promote their own merchandise, as long as they don't make or generate more than $100,000 per year doing so, which is a very strange limit for a transactional form that contemplates owners making money from what they own. And the third example comes from Bored Apes, which is a very popular collectible series that uses NFTs to grant a license. It's a series of collective unique apes offered on the Rarible and OpenSea platforms, where the buyer receives a license to use each version of their ape personally and for commercial use. And just let me give you an example of the license which exists in the platform, but not the NFT itself. And this distinction is super important. This is what it says in the examples here, the Bored Ape 6068, right? There are 10,000 of them as far as I know. The owner of Bored Ape 6068 grants the owners of this license Bored Ape number 6068 royalty-free usage license plus source files NFT, an unlimited worldwide license to use, copy, and display the licensed art, Bored Ape 6068 source files, for the purpose of creating derivatives, Bored Ape 6068 derivative art based upon the art commercial use, provided that you can cryptographically verify your ownership of the license, Bored Ape 6068 royalty-free usage license plus source files NFT. So what does it tell you? That the NFT is evidence of the legitimacy of using the licensed work. It does not really belong to you as an owner. Would Bored Apes owners care? I'm not too sure, probably not. They're very enthusiastic about these Bored Apes, but if you are a collector, serious collector, perhaps you need to look at the conditions and terms of use. And here are a couple of lessons, kind of lessons learned and afterthoughts and parting thoughts, generally speaking. Artists and collectors, beware. You really read the fine print. What is it that you're selling and what is it that you are buying? Sale of NFT should be a sale of personal property, but it's not. It's governed by the licensing regime in most cases, probably not in 100% of cases, but in most it will be under the licensing regime. It's not yet clear whether an NFT can lawfully transfer rights. Most popular NFTs, such as CryptoKitties and CryptoPunks, do not involve copyright transactions. If you're an NFT buyer, you may believe the hype. You have been told that you are the owners of all these valuable, unique digital assets, and you can capture the rise in the value of these assets as an owner would, right? Wouldn't you expect that? You as a buyer must have clearly parted with enormous amounts of money on the grounds that the token represents something different than merely the attached resources. And if you're a creator, you must have made some promises that NFT buyers are the owners of the property, and those words have bearings and have weight for courts. So you must be very careful what actually you're promising to the buyers. So the legal fate of NFTs depends on the characterization of them as property and the transaction as a sale, but it is currently not the case. I leave you with this, and I wonder what you think about that, about all these legal complexities and intricacies. Please write some comments below, and thank you for joining. I shall see you next Friday at 2 p.m. Dubai time. And now it's time for some music.